Good morning. My name is Justin Smith, and I'm a marketing specialist here at Reinhart, Borner, Van Buren. I'd like to welcome all of our attendees joining us today here in our Milwaukee offices, as well as online via webinar. We hope you'll leave here this morning with a clear understanding of the legal and insurance considerations for your 2015 Food Safety Plan. We recognize that 2015 brings new compliance, risk management, and safety challenges. Our goal is to simplify complicated issues and provide creative solutions so you can maintain focus on running your organization. I'd also like to welcome our guest presenters joining us this morning from Associated Financial Group. Nancy Moon heads Associated Financial Group's Food and Beverage Practice, where she focuses on risk and compliance solutions. Jim Kremer has a background in occupational safety, health services, and OSHA compliance. Jim moved to insurance in 1998 as an accident prevention consultant and has been with Associated since 2007. Jennifer Nager is the chair of Reinhart's Food and Beverage Law Practice Group. She counsels clients on regulatory matters, including product development, labeling, recalls, and food safety issues. She also represents food and beverage clients in litigation at the state and federal levels. Before we get started, I want to take the audience through some quick housekeeping procedures. Our online attendees may ask questions by typing them in the Q&A section of the webinar control panel. Our presenters will answer as many questions as possible at the end of the webinar. If you'd like to follow along with a hard copy of the presentation, check your email inbox. A copy of the slides was emailed to all attendees yesterday. And with that, I'll turn it over to Nancy.
Well, hello and welcome this morning, and thank you so much for joining us. Today, we hope that you gain better understanding of 5 key concepts for improved risk quality, claims results, and controllable insurance costs long term. What areas of exposure most impact insurance pricing decisions? In addition, what exposures and coverages are unique to your industry? What do carrier loss control representatives observe while visiting your facility and why? And learn more about how to favorably present your company to insurance carriers. Finally, we hope that you will discover how to capitalize on shared tools for improved business outcomes. This industry snapshot illustrates varied food processors and manufacturers, from very large multinational to small local family-owned and operated entities. Joining them are millions of farm, agriculture, import and retail entities comprising an amazingly large and dominant food-related economic engine here in the U.S. as well as globally. Of course, this creates new challenges as well as opportunities. We'll share slides referencing claims data from a CNA study in an insurance carrier with a large food portfolio and database to help you consider what trend results may be inherent to your industry overall, how you may compare, and where will you need to improve. As we proceed, please keep in mind the trends discussed are fairly consistent regardless of entity. Some of the top exposure areas for both general industry and food are indeed similar. Workers' compensation, of course, involves employee illness and injuries. Property occurs far less frequently, however, with more potential severity. Commercial auto is obvious in that it involves vehicle accidents, and general liability incidents typically involve products, completed operations, and premises. Additional exposures unique to your industry include product recall as well as contamination. These, of course, relate to adverse health, possible bodily injury, or property damage, and may adversely impact your brand integrity, consumer confidence, and sustainability, and we will certainly dig into that a little bit later. The CNA study lays out each of the top 4 exposure areas, illustrating top percent of total incidents and claims, as well as the top percentage of total claims dollars paid. Please note, as we review the slides, that highest severity exposure areas identified represent paid claims in excess of $100,000. Let's begin with the work comp. All slides presented will illustrate diverse incident types. In this slide, manual material handling and physical stress, including repetitive motion, are both categories likely to result in more incidences. You will also note that slips and the falls category, however, have the highest severity in terms of paid claims. Some incident causation examples include manually lifting, moving raw materials from receiving to shipping, and while loading and unloading product. Add in routine material handling processes such as cutting, wrapping, twisting, turning. These are all repetitive motion exposures. Now let's look at property. Wind damage, fire, and theft account for highest claims incidents. However, fire is by far the most severe in terms of paid claims dollars, followed, of course, by wind damage. Examples here include fire losses due to ovens, dryers, electrical ignition sources, careless smoking, poor housekeeping, and, of course, machinery maintenance. Wind damage typically results from hurricanes on the coast, and here in Wisconsin, of course, windstorm and tornado. In regard to vehicles, rear-end collisions are clearly the highest auto-related claims in terms of both incident rates and severity. Examples of causation include tight maneuvering, delivery, speeding, eating, texting, or other contributing factors. In regard to general liability, in this industry, many claims result from eating and drinking. Most severe are caused by foreign objects in food products consumed, which of course may cause dental claims and mouth injuries. Total causation, typical causation includes presence of non-metallic objects such as nutshells, fruit pits, and other food-related items. Please note that the category of contract of mold, fumes, and vapors includes scenarios involving potential product contamination and product recall, and therefore it may not be addressed in your typical general liability policies for full coverage. The highest severity claims, those over $100,000, involve at least in part some form of food contamination. Now, why is this important? You'll see on this slide that the likelihood of risk has grown exponentially as it is from the Center for Disease Control and illustrates foodborne illness statistics, which are pretty significant. 1 in 6 Americans will fall ill, 128,000 will be hospitalized, and 3,000 may die, all resulting from foodborne illnesses such as Salmonella, E. coli, Listeria, botulism, and as well as instances due to new and undiscovered and developing pathogens, somewhat without a clearly defined cause. Having said this, are incidences requiring recall action really increasing? Let's take a peek. This is actually a posting page from foodsafety.gov and reflects incidents from the last week alone. Information on this and other websites is regularly updated and available for public view, which in itself may be concerning and have adverse business implications. Why is this happening? Possible reasons include reliance on global supply chains is widespread, while global regulatory standards remain inconsistent. Secondly, the likelihood of human error still exists, even with improved implementation of best practices and technology. Increasing media attention regarding safety status of our food supply is often in the news and a fact of life. And consequently, the public is well educated, consumers and businesses alike. So, the adequacy of government regulation is therefore scrutinized by the public. Due to increased fear and pressure to protect the population, the domino effect is heightened regulation and more scrutiny on food industry operators such as yourselves. Larger companies may be more likely to invest in robust coverage, but there is a growing trend requiring contract manufacturers to have recall coverage placed as well, so risk is shared and more effectively transferred, because recall expenses can be very high. Some liken this evolving risk to cyber liability. While previous perceptions were conservative in the past, thinking that recall is just not likely to happen to us, just larger companies, statistically, like cyber, product recall, and contamination, today have increasing probability. It is truly not a case of if, but when you will either suspect possibility of adverse health, bodily injury, and property damage, or have an incident requiring actual formal recall action. To provide some protection and peace of mind, luckily there are several types of recall and contamination insurance products available. Some listed are here for reference. Accidental contamination, malicious product tampering, government recall, product extortion, and whether you or not you realize this is available, celebrity endorsement recall. If you co-brand with celebrities and athletes and are concerned about protecting your brand and reputation in the event that there's misbehavior or the relationship sours, you may consider this. Key points to remember when evaluating is that product recall and contamination is typically excluded on general liability forms and may be available via endorsement. Umbrella is also not going to cover this exposure. Separate standalone policies are certainly available and vary significantly in quality and cost. And finally, coverage triggers vary, either by government declaration following an incident or by reasonable suspicion of adverse health, bodily injury, and property damage. You'll notice there's a theme here. Various options are also available that you may consider and be aware of, in that recall expense coverage is available on a first and third party basis. First party, of course, is for your company. Third party is for you on behalf of a hired contract manufacturer, packager, ingredient provider, etc. We encourage you to include costs of lost productivity and revenue in calculation of various limit needs with other related expenses listed below, as there are tools that we can provide you to help assess these needs. Recognize and clearly present required underwriting data when asked to increase the comfort level of the underwriter. This is a very big factor. The underwriter will assign risk hazard grading of low, medium, and high after review of the submitted information and a loss control walkthrough. And this should also include any end users and quality information that you have as well. Revenue estimates by product for domestic and foreign sales will also be needed, and the question will be raised whether worldwide coverage is necessary. Packaging and labels, review of design, warranty, and documentation. is important. And this is where proactive legal advice is absolutely key. Claims experience will be important, and obviously the less claims you have, the better it is. But they'll typically look at 5 years, if not more. And then also explain and document your communication process that you have within your organization internally, and share that with the carriers so that they understand who will be fully accountable during a crisis and recall. That'll make them more comfortable. So I provide these summary questions for your individual and review with your management teams as a bullet point list. We certainly welcome the opportunity to provide additional resources and expertise to help you assess your operation. And with pleasure, on that note, I turn over our presentation to my colleague Jim, who is our manager of the Risk Management Solutions team.
Thank you, Nancy. Good morning, everyone. It's a pleasure to spend a few minutes with you this morning. I promise I won't go longer than, maybe 2.5 hours. So, I'm just kidding. Come on, that was a joke. So anyway, kind of to start off this morning, I would encourage you, we just heard from Nancy what some of our issues are in the industry, what some of our concerns are, our losses. Isn't it great to think of losses early on a cold winter morning? But I'm going to try to be a little bit more upbeat, and the thrust of my presentation is going to be how we prevent these terrible things from happening. So, again, as we get going, let me encourage you to use all the tools that are at your disposal. I'm sure within each of your organizations that you have a very strong, safety, risk management approach and risk management team. But enlist others, enlist people that can help you with your efforts. Two sort of folks that can help you would be the loss control people from insurance carriers and the loss control people from your insurance brokers. Now, there's an interesting difference there. Both people can bring technical skills that are useful, that, bring a different flavor, so to speak, to your organization. But the loss control person from your insurance broker works directly for you. Insurance loss control people work for an underwriter, and of course the insurance carrier expects to make money at the end of the day. So anything that might be controversial, difficult, those type of issues, vet those issues with your broker loss control person rather than with a carrier loss control person. As you go about prevention efforts, a team approach is critical. I go to so many companies, and they have excellent processes in place, but they're kind of silo processes. So the safety, the employee safety, workers' comp type thing is handled by one individual. Food safety and quality is handled by another individual. And maybe there's a third individual or fourth individual that does fleet type prevention, property type prevention, that sort of thing. You need to marry all of those processes together. And again, you can have subject matter experts, but a team approach is critical. Within that team, you need to have a decision maker. You need to have an individual that is able to commit your organization to a direction. Sometimes that direction is capital related, spending some money. Sometimes that direction is slowing down on product development. But your loss control efforts, accident, incident prevention efforts need to have a leader. That leader needs to be highly placed enough in the organization that she or he can truly make decisions. So I thought with the remainder of my 2.5 minutes or whatever we have now, it's a little longer than that, but with the remainder of the time that we have this morning, I wanted to return to basics. Now you might think, why are we returning to basics? Doesn't somebody want to say that? Nobody's saying that. Okay, so I'll tell you. We're going to return to basics because, again, in my experience, It is the basic issues that tend to get us in trouble time after time. The complex issues, the changes in regulatory, like Jennifer is going to discuss in a few minutes with the Food Modernization Act, Food Safety Modernization Act, we normally kind of catch those things, do a pretty good job. But the basics, I think, occasionally we need to go back and look at these things. So my hope is that in each of your organizations, you kind of, again, use this as a punch list and just be sure you have all these processes in place. So I thought we'd start with HACCP. I know you all do a fine job with HACCP. There's no doubt in my mind. That certainly was, many years ago, was a big change in how the industry focused on food safety. So you're doing a good job. Don't forget, though, that HACCP is not just a paper program. That program has to be a living document. It has to be reviewed. It has to be updated. When there are process changes, equipment changes, product changes, you need to be updating that HACCP plan, well, in some cases, actually, on a weekly or monthly basis. Very important. The next basic I wanted to discuss just a little bit is employee involvement. It is critical, I think, in any industry, but particularly in the food industry. I think it's critical to involve all of your employees. In the food industry, we tend many times to have flux employment with temporary workers, and there's nothing wrong with that. But even those temporary workers need to understand that they're part of the team, that their input is welcomed. The last thing that you want to do is shut down your workforce and put them in a position where they are afraid to mention things to you, afraid to bring concerns forth, and that type of thing. So again, with this employee involvement, it is critical that everyone in the organization be trained to use all of their senses. If someone sees something that they think is unusual, they smell something that's unusual, things just don't seem normal. That is something that you as leaders in your organizations need to find out about. That needs to come up rapidly so that if there is a problem, we can stop production, we can get problem products out of the supply chain. So we need to train people, and we also need to close the loop. If individuals come forth to you with concerns, with issues, again, you want to be open to those things. You always want to get back to those individuals. Now, many issues, you will run down, you'll investigate, turns out there's not a problem. Get back to the individual, let she or he know that you took them seriously. So I think the employee involvement engagement is critical. Another piece that's critical is leaders need to walk the plant. And again, I know everyone is so busy, but it's critical. Many of the folks in attendance at this presentation are financial people, have higher leadership positions. You are critical to be seen in the plant. You need to be out there. You need to be talking to people so that it's more than just your paper support of doing things right. Don't be afraid of walking the plant. And again, I know it's difficult time-wise, but get out in the plant, talk to people when you're out there, let them know that you are interested, that it's one of your key accountabilities to be sure that things are proceeding properly in manufacturing and processing areas. Product stewardship, of course, is critical. And again, in my experience, one of the things that gets us in trouble is getting lazy with our record keeping. We need to be able to track every product that we are selling or manufacturing or supplying, every product from, literally cradle to grave, so to speak, from incoming raws to outgoing finished product to the destination of that product. We need to know where all of our materials came from, where they're going. We just need to spend a lot of time on those kind of issues. So record keeping is critical. It is not a low-level position in food in the food and beverage industry. Record keeping is critical. We need to do that right. Be sure that you think of the recall drill. And again, my suspicion is that everyone in attendance here is kind of sick of recall drills, but they are critical. And just a couple of pointers, things that I've seen work well with recall drills. Be sure that you have a written program. Things like contact information, so important. Because it seems like a recall never occurs, on a Tuesday morning at 10 o'clock. The recall occurs at night on a weekend, so contact lists for people, names of critical team members, alternates, all of these things. The more you have written down, the more you've planned these things, that you have a reference document, the easier they become. So get out ahead of the problem. If something happens, just don't think, oh, it'll go away. I think I'm going to lunch. I don't think anybody would do that. I might. No, I wouldn't. But anyway, get out ahead of the problem, admit that there's something going on, and you need to really activate your recall procedures. Ethical, and again, I know that there's no issue here, but ethical and legal responsibilities. You need to be getting a hold of your legal representation. You need to be getting a hold of the people that can help you, which in case of a recall ends up being legal and ends up being your insurance partners. So again, with recall, drills are very important. You need to have at least an annual drill, and frankly, I think for most companies, annual is not often enough. But that recall drill should be unannounced whenever possible, so that you kind of hit people. You kind of pull them out of what they do on a daily basis. So do the unannounced recalls. Again, be sure that you involve alternate individuals, so that on the day of the real recall, if the person that heads up your quality department isn't there, there is another individual to step into that position. As you do drills, have a timekeeper. It's great if you can find all the records, but if it took you 48 hours to find those records, hey, you know what, we're kind of dead in the water on that deal. So have a timekeeper. Another thing that's very good is to have a non-company representative. And again, I would suggest maybe an insurance broker person that could act as that, sort of that straw person, but have a non-company individual there that it can honestly critique and offer suggestions. So employee safety, I thought that I'd just say a few words on employee safety. Food industry, it can be a very hazardous industry, to work in, food and beverage. A lot of moving parts there, literally. A lot of chemical exposure with sanitation chemicals. So in my practice of safety, what I try, really to push towards is to work towards the big three. To me, the big three in any manufacturing and distribution setting are safety, quality, and productivity. Years ago when I was young, about 3 years ago, no, that's a lie too, it was a lot longer than that, but when I was young, it was still popular to say safety is number one, safety is the most important thing. We don't say that anymore. What we say now is we want safety to be equivalent to productivity and quality, because within your organizations you will not risk those two things, safety and quality, productivity. So OSHA is alive and well, in case anyone was wondering. I was just with a client in Illinois till the wee hours dealing with an OSHA inspection yesterday. So OSHA is out there. Within your organizations, at the bottom of this slide, you will see the huge areas you need to concentrate on. And that is machine guarding, sanitation, electrical issues, and ergonomics. The top three are the issues that are going to cause the severity-driven accident, the bad, so to speak, bloody accident. The bottom issue, ergonomics, is really where the money is. That is where the claims are going to occur within your organizations. From a national standpoint, I just thought I'd throw this in. These are the hot-button issues that OSHA has going right now. The top issue, combustible dust, will impact many of you. Pretty much anything that we put in our mouths that started out as a solid material is combustible if we grind it up to a fine enough particulate. So things like sugars, starch, flour, all of those materials create combustible dust. It is a real hazard. I have seen combustible dust explosions. They are definitely not a pretty sight. Ammonia refrigeration. Many of you that have perishable product will have ammonia refrigeration systems. It's a wonderful refrigerant, although costs certainly have gone up recently. However, if you look statistically, ammonia is the #1 reason for hazmat responses in the United States. So if you have an ammonia system, you need to be sure that if you fall within process safety management, that is another issue you need to undertake. Typically, unless you're a very large organization, you're going to want a consultant to help you with ammonia refrigeration. You're going to want to have the name and contact info for a contractor available. You need a contractor that's available 24/7, 365. So ammonia is a big issue. If you remember back to that slide that Nancy had a few minutes ago, fire is the #1 loss factor. Wind loss is the #1 property loss from an occurrence standpoint, but dollar-wise, fires are our worst case scenario. If I mention one thing from this slide, be certain you have a hot work program. Hot work is welding, cutting, grinding, brazing in areas of the plant where you could have a fire or explosion occur. Most of my life I actually worked in industry, and in the plants that I was responsible for, any fires that occurred, doesn't sound good for a safety guy to say that he or she had fires, but anyway, the fires that occurred, every one of them was caused by a hot work mishap, somebody welding in the middle of the plant or that type of thing. Facility security is huge in the food and beverage industry, and from a standpoint of legal requirement, we need to do it, but from a standpoint of property and resource conservation, we need to do it. We should do it. So again, it's, you start out with the basics: lights, locks, fences, gates, signs, that type of thing, and visitor control. I would just mention to you, closed circuit TV has gotten much cheaper in recent years. So that is the end of my, somewhat quick walk through safety and loss control issues. There are a number of resources that we've provided you with. I hope you find them helpful. And let me just say thank you very much for your kind attention. Have a good and safe day, everyone.
Good morning. My name is Jennifer Nager, and I'm chair of the food group here at Reinhart. Today I'm going to be discussing the Food Safety Modernization Act. As I would expect for a lot of you, this is not a new rule. This law was passed by Congress in December of 2010, so it is almost at this point, and actually it was signed into law in January 2011. So at this point it's over 4 years old. Importantly, though, it was a complete overhaul of federal legislation relating to food safety issues. It really shifted the focus of the FDA from responding to contamination to preventing it. And you'll see throughout my presentation that the cornerstone theme here is prevention. So it's really important to think prevention here. Now, while this act is almost 4 years old, there have been a lot of recent changes. Last year, late last year, there were a lot of revised supplemental proposals that were made, and I'll go through those. So I only have 30 minutes to speak with you this morning, and I have a lot of information to cover. So I am going to skip over some of the more proposals that I don't think are really applicable to our audience here live and the viewers we have on our webinar. Specifically, the Produce Safety Act, I'll address it in a very high level, but I don't think it's really applicable to our audience. So if you have any further questions for me regarding it, please feel free to contact me if I skim over something that is important to you. So what I'm going to cover today are the reasons for the law's enactment, which I think will be obvious to the majority of you, the main themes of the act, and key provisions and their significance. So why is the law needed? Nancy actually addressed these points in her presentation. The CDC has statistics on this. 48 million Americans get sick each year. That's a really, really high number. Foodborne illness is an important consideration for all food processors, manufacturers, and producers. As I have some examples here of the recent outbreaks that have happened over the years. The ones that are probably most familiar to you are listeria in cantaloupes that resulted in 146 people ill and 30 deaths. That was Jensen Farms. The owner of those, of the Jensen Farms, actually pleaded guilty to misdemeanor charges, even though they did not know that the cantaloupes they were shipping into commerce were contaminated. They did not have knowledge beforehand, but they still pled guilty to misdemeanors. And the salmonella in peanuts, 714 ill and 9 deaths. That's Peanut Corporation of America. I'm sure everybody in the food industry is aware of that. the owners of the Peanut Corporation of America will be spending the rest of their lives in jail. They shipped contaminated peanut products and peanuts into commerce that were contaminated with salmonella, and they were actually found guilty of 60-plus felony counts. Other reasons for this law: U.S. food imports has dramatically increased over the years. It's nearly doubled since 2013. 15% of U.S. food supply comes from overseas. There's more types of foods in the marketplace, and there's a shift in demographics. There's a greater number of immunocompromised individuals who are consuming food: pregnant women, infants, elderly, sick. So the legislators really wanted to pay attention to this and really wanted to overhaul the system. So the main themes that I will be discussing today: prevention. So you'll hear it over and over again: prevention. The FDA has been given a legislative mandate to require preventative controls across the food chain. And I'll be discussing 4 proposed rules that the FDA, or that legislators have proposed here, that will fit into this theme, that food manufacturers and processors and producers must comply with. Inspection, compliance, and response. So the prevention proposals are only as good as the food processors and the producers actually comply with them. So the FDA must ensure compliance, and they must be given oversight responsibilities. So this act provides them with that. And they're also given tools to effectively correct any issues, any food safety problems that arise. And in my view, one of the most groundbreaking shifts is import safety. And Nancy and Jim alluded to this as well. Because so much food is coming from overseas here, now importers are responsible to make sure that the food that is coming from overseas is as safe as the food that's here, that is processed and manufactured here in the United States. It requires the importers to have a preventative control in place for all the food that's shipped from overseas. And enhanced partnerships. While I'm sure it's quite obvious the FDA cannot handle all of their responsibilities on their own, they're going to be paying particular attention and looking to local and state authorities to really help them out with a lot of their responsibilities. Okay, first thing I'm going to dive into is the prevention theme. And one of the most important proposed rules is the hazard analysis and risk-based preventative control for human food. And I think this is most applicable to a lot of our audience members here today. The ultimate goal of this rule is what you would expect: to prevent contamination in food. So who would be covered under this rule? The proposed rule would apply to any facility that is registered, that is required to be registered under the existing food facility registration requirements in the Food, Drug, and Cosmetic Act, Section 415. So any registered food facility must comply with this act, any food facility that manufactures human food. Examples would be, as you'd expect, manufacturers, processors, warehouses, storage tanks. Anybody that manufactures, processes, holds, packages, stores food must comply. And activities within the definition of farm would not be subject to this rule. And you'll see a theme throughout my presentation too, that farms are usually excluded from a lot of these proposed rules. It could be because they are perceived as low risk. It could be perceived also because they are very small businesses that don't have the means to comply with a lot of these rules, and the legislators have understood that. So with this act, food facilities must prepare and implement a food safety plan that Jim has talked about as well. Get out your recall plans, get out your food safety plans, make sure they comply with these elements. There are 5 elements that must be in every food safety plan. The first one is a hazard analysis. Get your team together. Every food that you manufacture or you process in your plant, there needs to be a hazard analysis for that particular type of food. You need to be able to identify and evaluate all of the known hazards and all the hazards that you foresee or that are reasonably foreseeable that could happen at your food plant for that particular food. And this could include biological, chemical, physical, natural toxins, allergen issues, parasites, decomposition, and that's just to name a few. And you must consider hazards that could be introduced intentionally as well as unintentionally. So the second element that must go into your food safety plan are, importantly, the preventative controls. And these controls must be used to minimize or prevent any of the hazards that you've identified in your food safety plan. And this would include your recall plan, your process controls, your allergen controls, your sanitation controls. All those must be included in the food safety plan. The third element that must be included are monitoring procedures. You must have procedures in place to make sure that you are monitoring the preventative controls to make sure that they are consistently performed. And you must keep records of these monitoring procedures. These records must be kept for at least 2 years. So every time you monitor this, you have to keep track of it, you have to record it, and you have to store it for at least 2 years. In case the FDA comes knocking at your door, they want to see records of all this. The fourth element are corrective actions for each preventative control if problems arise. Should one of the preventive controls not work, you need to make sure that you have corrective actions in place to help those issues. Minimize the reoccurrence of a problem, to prevent that food from being shipped out. All of these need to be in your food safety plan. And lastly, here are verification activities. You must make sure that you have these in your food safety plan to ensure that the controls are adequate for their purpose. So this is different than monitoring procedures, those to make sure that you are consistently applying them, the preventative controls. Verification is to make sure that these controls are adequate for the purpose that you have them there. Again, you must keep a record of all your food safety plan, all of the monitoring procedures and your verification activities for a minimum of 2 years. And you must reevaluate your food safety plan every 3 years. And this is required by law. You can't write your plan, put it on the shelf, come back in 10 to 15 years, dust it off. You are required by law every 3 years to pull it off the shelf, reevaluate it, or if there is a trigger in place, if you have aware of a new hazard, if your company purchases new equipment, or you decide to make a new product, or if you decide to put a new ingredient in your product, all those times you must take your food safety plan off the shelf and reevaluate it. This is something else that the FDA is going to, when they come and inspect your plant, which you'll see that they're required to do now in a more frequent basis, they're going to be looking for these points. And I mentioned before that there are revised supplemental proposals for the majority of these major rules that we have here that came into effect in September 19th, 2014. They requested for comment. The comment period is closed, and now we're just waiting for the legislators, the FDA, to decide on how they want to go forward with a lot of these new rules. And so I'm going to go into, I won't cover all of the revised proposals, but I'll just go into the ones that I think are most beneficial to you, that you need to know about. So farms that pack and hold food from other farms would not be subject to this rule. So farms, I said, did not have to do this, but if farms are accepting food from other farms or other facilities and they're holding them at their facility, that would be that they are now a storage or a packing plant. Under this proposed rule, they would not have to follow these preventative control rules. Again, it's the theme that they're considered really low risk and they don't have to follow them. They also amended, the definition of very small business. And with the compliance dates here, you see this is important because if you fit under a very small business, you have 3 years from the date that this final rule is enacted, which is August 30th this year, which is coming up very quickly. You have 3 years from that date to comply with this rule. So small businesses are anyone that makes less than $1 million in annual sales a year. So that was recently changed. They had 3 options. Was it 250,000, 500,000, and 1 million? And they decided to go with 1 million there. Another revised proposal, there are certain exemptions. For example, a farm they're exempt from this act. The FDA has now been given permission to withdraw those exemptions if there's a food safety issue, and they would require farms, if there was an issue, to say that they have to comply with these control rules. If that exemption is withdrawn, they're given 120 days to comply. That's not a lot of time. So they're given 120 days by law to comply with these rules if that exemption is withdrawn. And of course, the FDA can always reinstate that exemption if the food issue has been resolved. And the last one that I'm going to address here, economically motivated adulteration. The revised proposal requested comment on whether a hazard analysis should be required to address economic adulteration, and that would be intentional contamination for purposes of economic gain. You have someone coming in your plant trying to contaminate your food, to help them out, a competitor, or you have an insider employee, trying to contaminate your food, all things that the FDA thinks that now you need to have in your food safety plan. Compliance dates here, very small businesses have 3 years, small businesses have 2 years, and all other businesses have 1 year from August 30th of this year to comply with this rule. That's coming up very soon. The next proposed rule that I'm going to talk about is very similar to the one I just mentioned, but this is for animal food. So all you pet manufacturers out there, pet food manufacturers out there, this is for you. Who's covered? It would apply to all facilities that manufacture, process, pack, or hold animal food and are required to register as a food facility under the Food, Drug, and Cosmetic Act, Section 415. Again, this does not apply to farms that manufacture food for their own animals, and it does not apply to activities within the definition of farm. And as you would expect, this rule parallels the human preventative control rule. You must have a food safety plan in place. You must have the preventative controls, a hazard analysis, monitoring procedures, verification activities, all the elements we discussed for the human food plan. Importantly here, though, and I think this is a pretty important thing to point out, that the new rule establishes current good manufacturing practice regulations for animal foods for the very first time. These CGMPs would require pet food manufacturers to address hygienic personnel practices and training, facility operations, equipment and utensil design, among other things. So that was not required before, and now it is. The revised proposal, again, same time frame. Last year, they issued a revised proposal to this rule. A lot of them you'll see are the same as the human food one. The economic adulteration, they expect the same thing now in the animal food safety plan. Very small businesses have been revised to mean a company less than $2.5 million in annual sales. And importantly here, and I think this caused a lot of stir in the industry, the human food processors that were already compliant with the FDA food safety requirements for animal food that I addressed earlier, who supply byproduct of human food for production for animal food. A lot of times it was the brewers were supplying their wet spent grains to cattle to be fed for animal food. They would have to have complied with both the animal food rule and for the human food rule. And a lot of the brewers raised a lot of stink about that. They thought that it was very beneficial to them to sell this product, but it wasn't worth the time and expense that they were getting from it to comply with both this rule and the human food, because they would have to have a preventative control in place for all the animal food that was going out as well as the human food. And so the legislators, the FDA, realized this and they changed that, and it's no longer required. Of course, if this byproduct is further processed, being either heated or dried, then they're required. But if it's just being shipped out for animal food and they're not doing anything to it, they don't have to comply, as long as they're complying with the human rule. And again, the FDA is allowed to withdraw an exemption for food safety issues, but they can also reinstate that once the food safety issues have been resolved. Compliance dates here, it's the same, August 30th. Very small businesses have 3 years, small businesses have 2 years, and all other businesses have only 1 year to comply. Now, standards for produce safety. I'm going to address this on a really high level. If anyone has any questions or concerns, please feel free to call me or shoot me an email, and I'll provide you with a little bit more information on this. As you would expect, the purpose of this rule, again, is prevention. It's to ensure that fruits and vegetables that are raw agricultural commodities minimize the risk of serious adverse health consequences or death. So this is specifically focused on the Jensen farms out there that harvest, that grow produce, fruits and vegetables for sale as raw commodities. And of course, failure to comply with this and failure to comply with the preventative control rules, those are all prohibited acts under the Food Safety Modernization Act, which could mean high penalties, suspension of your registration, things that you don't want to have to deal with. So who would be covered here? Farms that grow, harvest, pack, or hold produce in raw or natural state. And it's farms with annual sales of greater than $25,000. Produce is defined as fruits and vegetables, and that would include tree nuts, herbs, sprouts, and mushrooms, and it does not include grains. And it would not include produce for personal consumption. So if you have a garden in your backyard, or you're part of a garden in your neighborhood, it would not be included in that. It does not include produce for personal consumption or on-farm consumption, and it would not apply to produce that is or fruits and vegetables that are rarely consumed raw. It would only apply to those that you ship out, like cantaloupe, that would be eaten in their natural state. And it would not apply to produce that will receive commercial processing. So the minimum safety standards that this law set really focus on the 5 routes of microbial contamination, which is irrigation, manure, animal encroachment, be it domestic or wild animals, worker health, hygiene, and equipment, tools, and buildings. They found that these 5 routes were really the ones that were leading to the most contamination, so they focused on those. And then again, there are special requirements for sprouts, and if you are growing, harvesting, packing, or holding this type of produce, there's requirements for you, meaning you can't, there's a specific type of packing material you must use when you ship your produce out. And you can't clean covered produce with excluded produce. There's rules for that. So if you want a little bit more detail on that, please give me a call or shoot me an email and I can provide that to you. Compliance dates. There's a little bit more time here. October 31st, 2015. Very small businesses have 4 years to comply. Small businesses have 3 years, and all of the farms have 2 years to comply. The food defense rule. So this rule is going to differ from the preventive controls rule in that this specifically deals with intentional contamination. They've thought of contamination due to sabotage, terrorism, any other illegal means that you can think of. And it really only applies to a very small set of companies that are registered with the FDA, those that legislators feel are the greatest target of inside terrorist attacks, those involved with bulk liquid receiving and loading, liquid storage and handling, secondary ingredient handling, which is the step where ingredients other than the primary food ingredient are handled before being combined with the primary ingredient, and mixing and similar activities. So as you would expect, the food defense rule parallels the preventative control rule in language and approach. You must have the food safety plan in place that takes this into consideration, the intentional contamination hazard into consideration. And you must have monitoring activities, your hazard analysis, all of the ones we talked about before. Exemptions to this, again, are on-farm activities, again, because they're low risk and they're very small businesses. Compliance dates for this are next year, March 31st. Very small businesses have 3 years plus 60 days from publication of the final rule. Small businesses have 2 years, and all the businesses have 1 year. I want to make this as difficult for you to comply with, so they mix up all the amount of years you have to comply. So the last proposed rule that I'm going to talk about under the prevention theme is Sanitary Food Transportation Act. So as you would imagine by the name, the goal is to ensure the transportation practices are safe, that they don't raise food safety concerns. And the focus of this rule are really on the 3 areas of risk, which are refrigeration, cleaning, and cross-contamination. So who is covered under this act? It would apply to all shippers, receivers, and carriers who transport food in the United States by motor or rail vehicle, whether or not the food is offered in interstate commerce. So food that is transferred just within Wisconsin, you have to comply with this act. And you really, as a manufacturer, you want to make sure that your shippers and that the people that you rely on to carry your food are complying with this act, because any food that is transported in violation of this act will be deemed adulterated. So foreign shippers are also covered under this rule, and that would apply to any persons outside the U.S. who ship food in the U.S. by international freight container, by ongoing vessel, or air freight container, and they arrange for the transfer of that container intact in the U.S. to be then put on a motor vehicle or rail, and then it's transported in the U.S. for use by consumers here. So the proposed rule would establish requirements governing equipment used to transport. So they really, again, focus on the main areas of contamination here, which is the vehicles and the equipment that's transporting. They want to make sure that the design and maintenance of the vehicles and equipment ensures that the food that it transports does not become contaminated. The actual transportation of the food is very important, so temperature controls, separation of food from non-food items, and other measures to ensure that food is not contaminated during transportation. It's really important that there is exchange of information between the processors and producers and the shippers. They want to make sure that everyone is aware of the prior cargoes that were in the motor or the vehicles, that there's temperature control issues or any other issues that have raised food safety concerns. They want to make sure that the transporters are communicating that to the distributors, to the manufacturers and the processors. Training here is important. The carrier personnel must be trained in sanitation practices. Again, you must maintain records of all procedures that you use to prevent food safety issues. Shippers and receivers must maintain that information, and the FDA has the right to waive certain requirements under this act for food safety issues. And again, food is deemed adulterated if it's transported in violation of these rules, so you really want to know who you're sending your food out with. March 31st, 2016 is the date of the final rule here. Small businesses have 2 years and all other businesses have 1 year to comply with this rule. On to a new theme. So I know I've covered a lot here in a little bit of time, and I have a decent chunk left to go here. If you have any questions, please ask them at the end, and feel free to shoot me an email or give me a call if you have any questions about what I've covered. New theme here is inspection and compliance. In order to assist the FDA in providing oversight and to ensure in compliance with the preventative controls rules, they really needed to require the FDA to inspect records and to increase the frequency with which the FDA or local and state authorities inspect facilities. So here, the FDA can have access to all your records. That's any records that have to do with importing, manufacturing, processing, and packing or distribution of food. So that would pretty much include all records except maybe financial records. If they have a reasonable belief that exposure to food will cause serious adverse health consequences or death. So if you have a recall and there's an issue, the FDA can come and demand access to all your records. And this is effective immediately. So make sure that all your records are in a place that you can access quickly and that they're organized. As I mentioned before, the FDA is required now to increase the number of times, I should say, that they inspect your facilities. Domestic high-risk facilities, they must be inspected within 5 years of enactment, once every 3 years thereafter. Other domestic facilities within 7 years of enactment or once every 5 years thereafter. And foreign facilities, at least 600 facilities per year, double the inspections the year after for the next 5 years. So the FDA does not have the bandwidth to do this, so they're really going to be relying on local and state authorities to help them out with this. And I should clarify here, when I say high-risk facilities, that term high risk, which you will see a lot throughout this act, has not been defined yet. They really haven't put a clear explanation on that yet. It's our guess that they will, but it's our guess that that has to do with facilities that have been involved with recalls before, facilities that the FDA have had to come back to numerous times to make sure that they're compliant. So those would be considered probably high-risk facilities. And again, this is effective immediately. So if the FDA comes knocking at your door, be ready. The next theme here is response. So the FDA must have tools in place to ensure compliance, and they must have tools in place to help to correct any issues if there are food safety risks. And one of this is pretty important is the mandatory recall authority. They don't anticipate using this very often because processors and producers have been usually really cooperative, that if there is an issue that would necessitate a food recall, they've done it on their own voluntarily. But now if the processor won't do that, the FDA has the authority to do it, to require that it's done. They can pull it back on its own. They're given expanded administrative detention. If there's an issue with your food, they can quarantine that for a longer period of time. They can suspend your registration. They have the authority to require import certification. There's enhanced product tracing and additional record keeping for high-risk foods. So they can come in and require that you keep a certain number of documents a longer period of time if you've been involved in a recall or they've had to come to your facility multiple times because of issues. And all these are effective immediately. So the next theme, and this is one I find the most groundbreaking theme, is the foreign supplier verification program. So for the very first time, importers are specifically required to have a program to verify that suppliers are in compliance with this act and that the food that they bring into the U.S. is safe. All importers are covered under this act unless they fit into an exemption. And the importer is defined as a U.S. owner or consignee of food at the time of the entry of the food into the U.S., or an agent or representative of that foreign owner at the time the food is brought here into the U.S. So all importers must comply with this act, the Food Supplier Verification Program. It's what you expect. They're responsible for verifying that foreign suppliers have adequate controls in place to ensure that the food that they bring here is safe. So if you import food here in the United States, know your supply chain. It's really important to know where your food is coming from, to know that the foreign facilities that keep their controls just as well as we keep them here in the U.S. It's really important that that's in place because it's only going to hurt you as an importer. Exemptions to this program would not apply if it's food imported into the U.S. for research or evaluation purposes or for personal consumption. Food imported for further processing, so if food is shipped over here and then it's further processed here in the U.S. before it's sent out for human consumption, it would not be applicable. Consumption for imports from foreign suppliers in countries with very comparable food safety systems. So as I mentioned before, if you know your supplier has systems in place like we do in the U.S., this could be a possible exemption for you here. And very small foreign suppliers with average annual sales during the previous 3 years of less than $1 million, you would not have to comply with this. The compliance dates coming right up, October 31st, 2015, 18 months from the final rule or 6 months after their foreign suppliers reach their Act compliance deadlines, whichever is later. And the last new rule that I'm going to discuss here with respect to import safety is the third-party accreditation. And I'm going to go over this relatively fast because I'm running out of time. But again, if you have any questions about this, please let me know. This is another way to ensure that the foreign food that we bring here into the U.S. is safe. It's a program through which qualified third parties can certify that foreign food facilities comply with U.S. food safety standards. So those third parties would be accredited laboratories and accredited auditors. So in order to determine who can be a laboratory, an accredited laboratory, or an accredited auditor, the FDA must publish model accreditation standards that they have to live up to. They must approve accreditation bodies who can certify these labs and auditors, and then those bodies will then approve and oversee the certification bodies. So what will accredited laboratories be used for? Specific testing required under law or by the FDA to address identified or suspected food safety problems. So if the FDA comes to you and says you must test your product, you have to use one of these accredited laboratories. It can be a government lab or it can be a private lab as long as they're accredited. Accredited auditors, again, can be a foreign government or a third party after review of internal systems and training. They must be sure, the FDA must be sure that they are up to speed on U.S. safety standards. And accredited auditors must be used for certification of high-risk foods and for certification under the Voluntary Qualified Importer Program. So that program, I can get into more detail if you're interested in it, but it would expedite entry into the U.S. of imported food from qualified eligible importers. So if you import food a lot from overseas, I would be, if I were you, I'd really get to know this Foreign Qualified Importer Program because it'll help you out a lot. And the final rule here, October 31st, 2015. So last theme here is enhanced partnerships. All food safety agencies have to work together in order to achieve the goals under the Act. They really can't do it alone. They were going to rely a lot on local and state authorities to help them with this. That's all I have here, today on the Food Safety Modernization Act. I covered a lot of information in a short period of time. Again, if you have any questions, please feel free to reach out to me and I can provide more information to you on any of these topics. Reinhart is going to have a booth at the Midwest Food Service Expo that is really geared towards restaurants and franchisees. If you're going to that, please stop by and see us. We'll be in booth 1020. For more information, check out their website. It's a really good expo. And that's all I have for you. If you have any questions in the audience, or I think we have some questions from the webinar. So a really good question here that I should have addressed. Can anyone in a company prepare a food safety plan as required under the preventative controls for food? No, not anybody can do it. You can't, the president of the company, just because you're president doesn't mean that you can write the food safety plan. You have to be what they call, quote, a qualified individual. And a qualified individual will be someone who has specific training in this. You have to receive specific training on how to develop a food safety plan. Or you have to be someone whose food experience, you have experience in this area, your job experience is enough where you have the background and able to do this, and you'll likely be required to prove that. So if you're a quality assurance personnel that has been in the industry for 30 years, you probably have the experience necessary to do this, and you would be a qualified individual under the law. That's all the questions I have. Did you get any questions?
Yes, actually we did.
There's some questions for Jim and Nancy, and they will be talking on their mics.
Sounds great. We were asked if there was a recall program template available for us to use it as a guide. And although there may be some templates available, perhaps Jim can speak to why using a template may not always be in your best interest.
Well, and that's a good question. There are a lot of programs that we use and that we like to template, and it works very well. I think recall procedures are one where we have, basic lists of here are the components, but it really has to be so customized to the particular organization, the product, that type of thing that, certainly we have a starting point. I think that we could provide you with that, but then there has to be work put into that for customization.
Right, and a final review to bring it up to all the compliance
that we
current
just, right,
standards.
Right, exactly.
Correct. All right. With so many options on the product contamination piece, do you have some sort of assessment tool? That's a great question, isn't it? We do. And to the point of the question, there are a lot of options, as we talked about. And there are actually even more options that might fit a very specific need that you have. Well, there is an assessment tool available that we can help maybe plug in some additional information to, and after some additional conversation, it would help us provide a guideline as to what coverage may fit you best. Hopefully that answers that. And then
the next question is sort of a repeat, a little bit of the first question. Is there a recall program template available for us to use as a guide? And again, we've certainly got lists of reference questions to step you through it, or that sort of thing. But I would kind of recommend against templating. Again, something I've seen just real quickly is that kind of in the medium, smaller, food and beverage type companies. They'll go to their neighboring business, get a copy of a plan, and just kind of scratch out the names and put their names in there. That does not work well, and that's pretty transparent if a regulator looks at, or an insurance carrier, or any of those type of folks that have the experience. If they look at one of those kind of programs that you've just sort of pencil whipped into shape.
Another really good question here, and that relates to says, how may we determine if our hired contract manufacturers, third-party providers, if they have or should have this insurance? And I think what they're alluding to is the product recall. And I think during the presentation I made a reference that there's a growing tendency now or requirement by larger firms to require that from their subs, which makes total best practice sense. And I think this really comes down to what your formal risk transfer process is as a company. And some companies do things a little bit differently than others. And obviously there's tools such as requesting basic certificates of insurance and addressing through a reference point of what those insurances may be on the certificate. But as we all know, sometimes those certificates aren't as detailed as they could be. So certainly, having a formalized risk transfer process that has a step-by-step process and individuals identified within your company that can assist with that process so that it's consistent and that coverage from your subs are updated on a regular basis. Make sure that they actually have their policies renewed and enforced with the appropriate parts is something that should be assessed, and indeed that is something we can help you with.
You know, I would just add quickly that risk transfer in food and beverage is different than risk transfer in widget manufacturing. And that is, you know, again, it's an area where you may want to involve, you know, your legal expertise and insurance expertise, because how the certificates, you know, how the wording is put together, you know, what's excluded, what's included, those I just have tremendous import depending on what kind of, you know, incidents could occur.
Right, and client contracts come into play too. And that's where, you know, legal advice is very helpful.
Any other questions? Thank you very much for joining us. We appreciate it.
Thank you all.
Thank you.
You have to finish all the food in the bag, or Nancy and I have to, before they let us leave.